And great. So basically, Tony and Nam, thank you very much for being part of the symposium. And I'm really happy that Nam has also come in. At least we have more people, more the merrier situation. So basically, both of you will have to just introduce each other, and then I'm not even interrupting you. The whole show is yours. Yeah, please. Tony, you want to start?
Thank you, Vikram. Firstly, I have to thank Vikram, especially for setting up this amazing platform for us all to speak about our own experience on jurisdiction basis in relation to mediation practice, and particularly the counter issues in mediation. We all know that mediation is about the way that people treat each other, and it's more on the mental rather than physical stuff. I introduce myself. My name is Nguyen, but people call me Tony. I'm the owner of the firm EP Legal in Vietnam. I practice in both Vietnam and in the UK. So I'm a dual practicing lawyer. But a majority of my work is in relation to disputes, and part of that is mediation. I act for my clients in mediation session, and I also act as a mediator. And my second part-time job is with the Vietnam Mediation Center. I help with the establishment of the VMC, Vietnam Mediation Center, and currently I'm having the role of Deputy Director of VMC. So that's all about me, and today I'm very glad to be sharing some of my knowledge and experience with a very well-learned co-mediator, Professor Chandran Nam. So I will pass on to Professor Nam to introduce himself before we continue.
Thank you, Tony, and thank you, Vikram. My name is Nam. So also in Vietnam, we have the same name, first name Nam, but he much more younger than me, but he's very talented colleague. As you see that Nam now is a deputy director of the VMC, that means Vietnam Mediation Center, wherein I am a mediator. So I joined the VMC from the date of it forming 2 years ago. But before that, I joined the VIAC, that means the mother organization of VMC, and we call it Vietnam International Arbitration Center. So I have been with the VIAC for 20 years, and then my full-time job is I am associate professor and dean of the Faculty of Law of the National Economic University in Hanoi. In the area of mediation, in 3 years ago, I was involved in the APMF, that means the Asia Pacific Mediation Forum, that organized in Da Nang City. And I was involved with the board of members. At that event, I had the chance to present a paper, How Law Faculty in Vietnam Can Promote Mediation and Negotiation Skills. So today I am very, that is my pleasure to attend the symposium that initiated by Mr. Vikram. And I hope that my colleague, Mr. Nguyen Trung Nam, I mean Tony, have the wonderful presentation. So I would like to leave the floor for you. Thank you.
Thank you, Professor Nam. Let me start with sharing the agenda with you in form of a PowerPoint slide.
So I would like to send our warm greeting to Giovanni, right? Our Italian friend, and Mr. David Simoni.
They'll be unmuted at after the presentation. We'll definitely have a chat with them.
Yeah,
sure.
We will have a Q&A session, so save the best for last. So our focus today is on the culture, and we come from an agriculture country, Vietnam, and as of now, agriculture is still playing an important part in the Vietnamese economy and social life. We cover some few topics in my presentation. Within about 30 minutes or so, I'm going to talk about the grassroots mediation from the very basic disputes between people and people in land-related disputes. And secondly, I will talk about a little bit about some other types of mediation in Vietnam and how the practice is being in place and the legal framework and how it reflects the culture of mediation in workplace disputes and in court annexed mediation. And then I will touch a little bit on commercial mediation before I give the floor to my colleague, Professor Nam, to talk more about commercial mediation. And then I will address the situation of Vietnam in relation to the Singapore Mediation Convention. For short, it's actually a very long name of Singapore Convention on the recognition of the mediated settlement agreements. And the final topic I want to touch upon is coming online mediation perspective of Vietnam, which VMC, Vietnam Mediation Center, also play a very leading role in it. Mediation in land-related disputes, it has been the most basic type of disputes in the life of the Vietnamese people. So everyone has a living, they have a house, and they have usually most of the time they will have at some point they will have disputes with their neighbors, right? So the legal basis currently for this type of disputes settlement is resolution number 4, 2017 of the councils of judges. And basically what it says is that before you go to court, you will need to settle the disputes by mediation within the community where you live. And according to the statistics of the MOJ, Ministry of Justice, from 2016-2018, the rate of successful land-related mediations was 82%. So it's really a great number. And why is that? It's because in the first place, the dispute is between neighbors, people who live around you. So it comes from the very core culture of the Vietnamese community, which is really agriculture based. So we live in villages, and the mediator in solving these disputes between these neighborhood people, they are elderly, or they are chiefs of the villages, and this is what we can call grassroots mediation. So every time you have dispute with your neighbor, the first thing you do is to come to the we call it the group chief or leader of the group where you live within a few number of households, and these people they are old, and they are respectful people. So most of the villagers listen to them, and that's why it explains how the mediation successful rate is very high, because of these people, they understand all the culture of the people. When they give advice, people listen to them. And the culture of the whole Vietnamese village community is from this grassroots mediation. So we can see that it has been in place for a very long time, and it has been reflected into the law of land-related disputes. And we can see that most of the disputes are successfully settled by mediation. And those mediators, they are not professional mediators. They don't have the proper training in mediation, but they have the most necessary skills, and people listen to them. So they don't need to learn much to obtain the successful mediation settlement. Because the law has reflected that you have to do the mediation first before you go to court at any level. So it is another powerful tool to make mediation more successful in that land-related disputes. We come to another type of disputes, which is labor disputes, or we call workplace disputes. In Vietnam, this is normally done by law. It is required to be mediated compulsory by certified labor mediators. But we have a different angle here with compared to the land-related disputes, where we see that it is not as effective as the land disputes, because of the two reasons. One is the limited access to labor mediation by the workers. So the workers, when they work with their employers, they usually under the pressure of the subordinate relationship between the employees and the employer, and they do not know much about the mediators who are certified by the MOLISA, the Ministry of Labor, and the linkage between them are not as good as we can see in the community land disputes. So in the land disputes, we'll see that the mediators are amongst the disputing parties. They know each other very well. But for this labor disputes, we do not see much of a high rate of successful mediation, even though it is provided by law that you must go with mediation, and it must be solved by it must be settled before the certified labor mediators. And the lack of relationship between the mediators and the Commission on Vietnam Labor Dispute Settlement is also another issue. So from our witnesses, we do not see that it is efficient as it should be. Another type of mediation that has been long been part of the dispute process in Vietnam is court-annexed mediation. So in the past, when the judge deal with the litigation case, usually he or she will bring the parties together and tell them to mediate. So the judge will also be the mediator, and he or she will tell the parties, normally using the reality test. And I have been personally participated in a few of these litigation court-annexed mediation. The judges will separate the parties and have private meeting with each of them in turn. And usually he or she will tell the party how bad the situation will be if the disputing party refuse to take an offer from the other side. And by doing the same tactics to the parties in turn, the court will narrow down the gaps between the parties, usually in terms of an amount of money to be paid, maybe from the respondent to the defendant to the claimant. And it has some problems. The problem is that the judges don't have mediation skills. they don't bring the parties into the correct environment where the mediation process could be best dealt with. So in the environment of a very high pressure court boardroom, usually parties feel very nervous and they don't actually they are not open to speak everything that they want to tell the judge. And secondly, everything that they tell the judge could be back against them at some point. So that is like the second issues with the confidentiality, because the judge will be at the end of the day the decision maker of the disputes if the parties could not reach agreement. And it leads to the third problem with this type of mediation, is that when the parties are in the fear of being forced to go to settlement, they are not happy with whatever it is, the solution. And that is against a very basic principle in mediation. You must be, as a disputing party, you must be willing and you must be happy to enter into any settlement arrangement, and not because of someone else push you in pressure you to have the deal. So that is the situation that we have before the law on mediation and dialogue at the court 2020, which came into effect on the 1st of January 2021. This new law has been introduced actually to address that problem. And what new in this law is that the mediators now will be separated from the judge. So you will, when you bring your case to the court will tell you to bring your case to a mediation, to a mediator before you can continue with the proceedings. And the mediators are a separate body. So it will be a neutral, and the mediator will be agreed by the parties. And therefore it will avoid the situation where the parties are afraid to come into mediation process. That is one thing. The other thing is that the government is trying to improve the quality of the mediators. So they are programming for the training and development of the skill sets of the mediators. So that is the plan, and it is too early for us now to assess whether it is successful. But at least from the intention and the direction of the lawmakers and also of the policy makers, they seem to be in a very good direction. So it has been in place for 9 months, and we have seen like a few reports from different provinces, all the favorable results, and they treasure the results of the mediation with a separate process. After that, they will come back to the court if the mediation is not successful. So that is another type of mediation. And in the past, it was quite bad in my experience, but it has been improved. And we can see that in the future, it will get even better and better in our view. I'm trying to move on. The next one I would like to talk about, where I can invite Professor Nam to provide input to that, is the commercial mediation in Vietnam. In the past, it was not regulated by any specific piece of legislation, but in 2017, it was in the first time introduced the Decree 22, which set out the legal framework for commercial mediation in Vietnam. It set out the conditions, the principles for the disputes, and the quality and the qualification of the commercial mediators, and how the procedures for commercial mediation take place, and the regulations on mediation institutions. So VMC, Vietnam Mediation Center, is actually the first mediation center established under this degree. And also the operation of the Vietnam-based foreign commercial mediation institutions. So it set out quite a lot of information. And it provides quite the same background as a model law on mediation in relation to the voluntary and equality principle, confidentiality, and the content of the mediated settlement agreement. This type of principles are embedded in the Decree 22. The only unfortunate thing I think about this piece of regulation is that it is not a law. So it is not equivalent to the law. It is only a decree, and we are aiming to promote this to become a law on commercial mediation. So in the near future. I would like to invite Professor Nam to give some comments and input on this. Professor?
Can you hear me?
Yes, we can hear you.
I think that Tony and Nguyen have prepared some further information on that. So I would like you to go further, and then I would like to join you in the last section. We call Q&A or on comment, because I think that you have something to share with us.
Okay, that's fine. Yeah, in that case, I will continue. So the procedures under Decree 22. Thank you, Professor Nam. So the procedures under the commercial mediation under the Decree 22 is that the mediator will be appointed. That's the first step. And the parties need to agree on the appointment of the mediator. And it could be selected through mediation institution, like VMC, for example. And then they will have to agree on the time and place of the mediation process, and also on the order and procedure to be agreed by the parties. And normally it will follow the rules of mediation institutions, because most of the time the parties do not object to that. Or it can be suggested by the mediator. I have to note that at any point of time, any party to the mediation process could just walk away. This is a key principle that we all know, that set out the basis of the commercial mediation, or in fact any mediation. And the mediation process will terminate when the settlement agreement is reached, or after the mediation process. The mediator believes that it has to terminate without a result, or it is by a request of a party. So basically, it's based on voluntary basis. And the Decree 22 also provides some regulations on the validity of the settlement agreement resulted from mediation. We call mediated settlement agreement, or MSA. And when a party has a request for the recognition of and enforcement of the MSA, he has to ensure that the party shall perform the obligations. And there's a time limit for such requests, which is 6 months. As of the date of the agreement. And also there are a few conditions to be met. In particular, the parties to mediation agreement, settlement agreement, must have sufficient civil act capacity. So they must be legitimate, registered under the law. The parties to the mediation agreement must be persons having the right and obligations to what the mediation contains. So it must be between the parties having the related rights and obligations. Either or both parties must file the application to the court for recognition, and the content of the successful mediation settlement agreement are voluntary and are not contrary to the law, not contrary to social ethics, or evasion of obligations toward the state of a third party. So that is the conditions for the mediation settlement agreement to be enforced. I think I will bypass this because the time is not with us at the moment.
No, there's enough time, Tony. You take your time. Take your time. You have enough time. Next session only starts in the next 1 hour. I've kept a little gap basically for me to take a break, but I won't take a break. You please take your time. Take your time.
Yeah. I want to go through another interesting topic on the question that we have just talked about in the last 2 years. I think Vietnam, how and why Vietnam has not been part of the Singapore Mediation Convention. Vietnam is the next neighbor to Singapore, which put a lot of efforts into promoting this mediation convention. And the convention is named after Singapore, in fact. The convention was adopted in 2018, and it was open for signature on the 7th of August, 2019. Many of us, including myself and a lot of our colleagues here, if you are listening to this, have actually been part of this signature ceremony in Singapore. I was there for 3 days. A lot of big celebration, and we keep counting each one of the signatory, the people representing the countries to come and sign. 46 countries, actually, states to sign it on the very first date of the signature opening. And after that, it has been now 55 countries signing the convention, but only 7 countries have ratified it. So we have a little bit of queries here on the number of ratifying countries, but let's save it for now. The convention is actually all about the framework for recognition and enforcement of mediated settlement agreements that resolve the international commercial disputes. And from practical perspective, many people believe that the convention is more of a spiritual effect, because in the first place, this is not the same as the New York Convention. New York Convention is about recognition and enforcement of something settled and decided by a third party, by a third person, and not by the parties themselves. But in case of mediation settlement agreements, the agreement is made by the parties, and they are happy about it. So there should be no reason why they are not voluntarily performing the terms of that settlement agreements, because they are happy to enter into it. And the convention, in that sense, is more like a promotion of like a second safety net for the settlement agreements to be enforced on an international arena. And Vietnam has seen the benefits in joining the convention. Obviously, Vietnam has been a member of the UNCITRAL Commission, and we want to be seen by the international parties as a promotion, as a promoter of international treaties and unified platforms for international trade, including the Singapore Mediation Convention. So we promote the trade, we promote international relationship, and we should promote the Singapore Convention. And it will assist us, firstly, to look great in the eyes of the international foreign parties, and it will assist the Vietnamese companies to expand our international businesses. When we are part of the Singapore Convention, the Vietnamese companies can enforce their mediated settlement agreements in all the member countries, member states of the Singapore Convention. And it will contribute to the improvement of the Vietnamese regulations on mediation. As I mentioned before, we only have the Decree 22 instead of a law. So if we can somehow develop our law in line with the Singapore Convention and the model law on mediation of the unseen trial, we will harmonize ourselves, our own regulations with the international best practice. And at the end, it will promote and encourage the mediation practice in Vietnam. But why Vietnam was not there in the first place? We were invited by the Singapore MOJ to the government of Singapore to explore the opportunity for Vietnam to sign the Singapore Convention. But at that time, in 2018, we were still considering the very new introduction of the convention. So it was a little bit of a hesitancy. And at that point, the existing platform for enforcement and recognition of the mediated settlement agreements in Vietnam was considered even more advanced to the one under the Singapore Convention. I will touch upon that later. And therefore, if Vietnam wants to be a part of the Singapore Convention, there will be cost for admission. So these are a little bit of comparison between the Vietnamese existing framework and the Singapore Mediation Convention. In terms of enforcement, the Singapore Convention on Mediation provides that each party to the convention shall enforce a settlement agreement accordance with its rules and procedure. Under Vietnamese law, we do not have any provisions on, it's now open. We have no provisions on non-Vietnamese mediation settlement agreements. Secondly, in terms of grounds for refusing to grant relief, which is the most important focus article in the Singapore Convention, there are a few grounds that you can see on the screen. Like, for example, item 3, the obligations in the settlement agreement have been performed or are not clear or comprehensible, or the granting relief would be contrary to the terms of the settlement agreement. So a few of these grounds. Under Article 5, they are essentially different from the conditions to enforce or to recognize a mediated settlement agreement under Vietnamese law. In particular, the Civil Procedure Code in Vietnam, it provides that the 4 conditions I mentioned before: sufficient civil act capacity, the parties are persons having rights and obligations towards the mediation contents, and each party or both parties have filed the application to the court. And finally, as long as the mediated settlement agreement is not contrary to the law, not contrary to social ethics, nor for evasion of obligations toward state or third party. So it's like a fake agreement. Then it would be enforceable under Vietnamese law. So they are quite incompatible in some way. And that raised the issue of admission costs. There will need to be possible amendments to the law in terms of Civil Procedure Code the law on enforcement of civil judgments, and the law on commerce, and the decree on commercial mediation. So there will be certain requirements under the law. And we also consider some concerns by the government when we admit to the Singapore Convention. There need to be some education, more understanding on the convention. Until now, we have very limited resources. Very few people have written on the Singapore Convention, especially in Vietnamese. We do not see that much. And I'm joining part of the MOJ experts team to do one of the very first researches on this. And then we will have to lobby the government and the parliament to accept that the Singapore Convention could be part of the Vietnamese law. And we also need to consider the development of the mediation practice in the context of Singapore Convention. And also in this context, we need to see whether Vietnamese legal profession has been ready for mediation practice. Most of mediation in Vietnam nowadays, we do not see the presence of legal representations. All the parties come to mediation process by themselves. They don't have legal representation, and they don't understand the essential issues in terms of legal concepts. So we see regularly inquiries by the parties, something like this. We have agreed on the key terms. Can the mediator help us prepare the agreement so that we can review and we can signify it? So that is something that is quite new to any mediator to take. You can't prepare the agreement for the parties. It's really the job of the advisors of the parties to do, and not the mediator. And also we need to consider the relationship between mediation and arbitration in the country. So all these are considerations for Vietnam to join the Singapore Mediation Convention. Next, we would like to talk a little bit about the online mediation practice in Vietnam. The reality is that we are having a booming development of online transactions and, of course, online disputes. Everything is happening on the internet, especially with the COVID-19 situation. So Vietnam is not different from other countries. We are having so much potential for disputes being settled by online mediation. And the development of e-commerce and the ODR is hand in hand, we think. But we still see a few difficulties in developing the online mediation in Vietnam. In fact, if you look around the market, you will see that only at the moment there are only two established online mediation platforms, and including one from Vietnam Mediation Center. We have established one I will introduce a little bit later on, and another one from Hanoi, Hanoi International Arbitration Center. But they are very new, and they are too unfamiliar with the disputing parties. Most of them believe that because the dispute value is too small, they don't really mind having it settled by mediation or any other type of dispute settlement online. They usually have the internal claim process within the platform themselves. So that is some difficulties. And the enterprises in Vietnam, they are still reluctant to approach this idea. And that's why it's still not very popular in Vietnam. Talking a little bit about the MedUp as a first initiative in Vietnam, a new platform was introduced on the 1st of April 2021 as the reaction to the COVID-19 situation. And I have the privilege to be part of it from the very beginning, and it launched the MedUp online mediation platform. You can see the smiley face under the MedUp logo. We initiated the online mediation platform with a view to promotion of online mediation and mediation in general to the whole public, and also B2B and B2C disputes. And starting from the electronic disputes, so all the e-commerce will be the future clients or customers of our platform. And the MedUp resolve not only the new electronic disputes, but also traditional commercial disputes. That is the aim. And we have the single platform for everything. But I have to say that this is still quite new to everyone. And we are in the process of trial to the market. And it's quite brand new in Vietnam. A bit about the more traditional way of mediation in Vietnam Mediation Center. As a first mediation center in Vietnam, it was officially established on the 27th of April 2018. And it was the first unit to provide the professional commercial mediation service under Decree 22. And VMC built up the experience and creditable experts on the board of directors. Most of the mediators of VMC are accredited by CEDAR, the very prominent trainers in mediation in UK. And we got the support from the MOJ and the IFC. That is basically what I'd like to cover for the 6 sessions. Now, maybe Nam, Professor Nam, can you jump in and make some contribution to that?
It's up to our master today, mediator Vikram, to want me to tell something. But I think that the 6th issue that presented by Tony Nguyen is already full in our program today. And because at the beginning, I just talked that I am from the Faculty of Law from the National Economic University. So probably Vikram would like me to say something about mediation from the eyes of a law professor.
Absolutely, absolutely. We need your inputs.
Okay, so let me share can I, Tony, can you display, and then I will stop sharing, and then I will share that.
Just allow the multi-share so we can share now.
Really? Okay, so how can I do so? Okay. Can you see that?
Yeah, yeah. If you want to start the slide presentation, we'll be able to see it bigger, so it'll be nice.
Okay. The topic is how to promote mediation skill for law faculties in Vietnam. So at the beginning, I already told you that I am a mediator from the VMC, that means the Vietnam Mediation Center. However, it seems that VMC and some other center in Vietnam are still new for the society. And we understand that in order to promote the culture for mediation, then we should start from the what we call the university, and then from the law faculty, right? That is true not only in Vietnam, but also in India or other country. So I would like to just to release some kind of we call fact that even now our law faculty often lack of mediation skill, and it is not introduced enough in our law schools, probably because we have to be strict on our curriculum. So in my university law school, we educate students for 4 years, and then all of them have to comply with 130 credit. So that's why actually we do not have a separate subject on mediation in our teaching curriculum. So that's why there's no teaching. Then how can we raise our awareness about mediation, right? And also mediation is a some from the consideration of some faculty member. They are still in a complex process. However, if we look at Tony Nguyen presentation today, I think that it is very, very simple, right? But because they are not familiar with mediation, then they consider that it is still a complex process. And so now I would like to touch on also the situation about the in Vietnam. So up to now, we have about almost 100 legal training institutions and faculty in Vietnam. So my faculty of law is belong to the National Economic University, but we educate lawyer, legal expert, and lawyer in the near future. However, most of our lecturers are untrained about mediation and mediation skills. So luckily, because I was supported by a program that funded by World Bank IFC, and then that course conducted by CEDA that Tony just mentioned before. However, we have in our faculty, we have the 30 faculty member, but we have only myself to participate in that program. So that means most of my colleagues, they are untrained about mediation skill. And then, so that's why when we have the World Bank IFC program on mediation training, and I hope that we have to multiply that into many training courses. So that's why about a lot of training, legal training institutions in Vietnam, they also benefit from that. But unfortunately, at this moment, any training need to be, that means we need to pay great attention on who do training, and then who are the potential trainee, and then what kind of certificate that we would grant to the trainee when they finish the training, and then what are the markets. Talk about markets, and then I also give you this is a funny photo that nowadays the markets in Vietnam is very small when we talk about mediation. So let's talk about arbitration. Arbitration in Vietnam is also we have what we call the cầm xí cầm xả. So that means so. That means we do not have much cases. However, we at our VIAC, I have about 3 to 5 cases every year, and then I think that it is enough for a full-time law professor for me. However, in terms of mediation, when I joined VMC in 2018 up to now, actually we have only 1 case, and then that case I was demanded to do, but at the end of the day, my colleague did that for me. So that means the market is still very small. And so that's why small demand. And then if we have the huge supply, that could be a surplus. So that's why I think that in order to promote mediation in the law university in Vietnam, then we have to start from the faculty member. If they do not recognize about the significance of mediation, and then about the how to meet the need of the market, then there will be no movement. So and then this is a big question that we have to build a mediation culture in our not just in the whole society, but particularly in the university where we educate lawyers. It seems to us that they still confuse mediation, commercial mediation, with the cost and mediation. So that's why some of us know that I am a member of the VMC, but so they tend to ask me how what relevant from VMC to the courts. So that means from that perspective, that means they understood nothing about commercial mediation. And then mediation must be adopted as a part of our law curriculum. I think that if there's no part on the law curriculum, then nobody study about that. In my faculties, we have the optional course on, we call it ADR. However, in ADR, we also teach negotiation and mediation, and as well as mediation. So that's why mediation counts a very small portion when we teach the ADR in the law faculty. Well, since the beginning of the symposium, and then I observed about a number of colleagues, mediator, and then I know that almost no one talk about in order to promote mediation, we have to carry out a serious campaign on ADR in general, and on mediation in particular. And also we have to prepare the handbook for mediation, and then to circulate it in whole university and colleges. And that could be used as a standard work for the training of the judges, training of the lawyer, and training of the mediator. At this moment, I think that under the VMC leader also very ambitious. We already carry out some what we call the pilot program for training of the mediation, but we target on the business community, not for the academic society. So that's why we need to have the curriculum, we need to have the handbook in order to give the tool for training of the mediator in Vietnam. And nowadays, I think that some of us appear on the TV, that means the Vietnam television, both Tony Nguyen and I, we are on TV channel 2, and then so we try our best to disseminate about mediation, so people understand about that. However, I think that it happens about several times a year, and it's never enough for the society. So I hope that I do believe that by the international symposium that initiated by Mediator Vikram, and then now the younger in Vietnam, they can watch that on the YouTube, and then they also can enhance their understanding about mediation, and then the culture of mediation. So I think that I would like to end up my contribution to Tony Nguyen. And then I would say that I highly appreciate Mediator Vikram. And I think that what you have done and you are going to do will benefit not only the whole society in the world, but also it benefits the younger in Vietnam. So nowadays I have 6 classes per week, and then I always give out the homework exercise to our students about ADR and including mediation. So Vikram, I think that can you believe that you will be one of the hot we call the forum for my teaching curriculum nowadays. Thank you so much.
Thank you, Nam. Thanks a lot for those kind words. It's very nice of you. And you skipped a lot of slides. I thought you're going to take us through all the slides. It's so nice. Your presentation also we needed. I don't know why you skipped that.
Actually, because we must give the floor for the Q&A, and we should not forget that the main speaker today is Tony Nguyen. So I am only the supporter.
You know, you both main speakers, and we have time because I asked David, because his session is at 7 o'clock India time. It's 6:30 right now. He said he wants to start at 7 o'clock only because the people that he circulated the information on, they're going to come at that time only. So we have time. So time is not a worry. But I tell you, the interesting thing, I mean, this whole land-related mediation that you spoke about, I think that's very interesting. That's something that if you can elaborate more on that and what's been happening there, if you have statistics there, something on that, if whoever, I mean, between both of you can tell me. But I think that is really should be an area where we should be looking at Vietnam, and you doing something at the grassroots level. I think it's very good.
Tony, please.
Thank you, Vikram. Yeah, I need to echo Professor Nam that this is really an amazing platform for us to share a little bit more about the grassroots mediation and culture in Vietnam. I can say that in the very old history of Vietnam, the agriculture practice and economy always play the major part in the life of each and every Vietnamese citizen. So every person in Vietnam will have a mother, a father, or a relative who is doing agriculture. So we have like 80%, even now, about 80% of the Vietnamese economy rely on the agriculture products. And as agriculture cultivator, we live within the countryside area, and we have the small communities. We have communes, we have villages, and these villages all together will form up a bigger unit of population. And because of that level of spread out down, you will see that most of the disputes at the unit level can be dealt with by the elderly and the chiefs of the villages, instead of some formal person like a judge or a court. So before going to court, you always come to talk to the elderly in the community, and people listen to him or to her. So if, let's say, he say that in these disputes, in the past, our village always deal with this in the form of, like, for example, you give some and A give some and B give some, or we can build up the separate fences if they have like small disputes on the border over the land. Things like that can be easily dealt with. And I can extend this to any other type of grassroots level disputes. For example, dispute within domestic disputes, like between husband and wife, family disputes. Usually the elderly in the village will come and talk to them as a father, as like a great grandfather to to the youngsters. So you are still young and you have like a lot of things to consider. Don't just blow up everything. So things like that, they are very simple, but very much embedded into the daily life of the culture of the communities. And they are very small. Like, for example, in a village in Vietnam, there are not more than a few hundred households. So they for one commune to be formed up. And these communes are very strong, tied up. For example, I came from my hometown in Hanoi. Nowadays, it's a central part of Hanoi. But my mother, when she get married to my father, she get to know by all the others, by other people in the village. It's still in the small village. People come and go, but everyone who joined the community in that village, they will get known by all others. And there are a few old people in the village who knows everyone and who know how the people's life are. And this is very different from the Western style of living. In the Western style, you don't know what happened in your next door. So your next door flat, if you are on flat like 1204, you don't know what happened in flat 1203 or 1205. You never know, and they don't want to tell you anything. It's a private life. It's a lot of great privacy. But in Vietnam, if my son get hurt, the other family in the very first of the village will know, and maybe they will come and give us some advice and also something, some kind of treatment to my son. So it's a lot more like a cohesive environment, and it still exists until nowadays. That's explained why all these type of grassroots mediation are so successful. And when the law impose something else, something different from that culture, the problem comes up. We don't have the successful rates, or the mediation result is not as good as what we can see from the grassroots mediation practice. Yeah.
Because you've picked up, yeah. I mean, this is exactly what you've put across are the excellent points that we really need to spread, that those communities which have been the close communities, they are well equipped to resolve their disputes in their own way, and mediation is a very good process for them. So definitely that, and this aspect that people have moved away from this community aspect and leading very individualistic lives, and that definitely is affecting dispute resolution. So we need to bridge this gap somehow. Any ideas? Of course, Nam, being a professor, will have some ideas on that this individualistic societies that we've developed, and how do we go back to that community aspect, where that missing link is. A little bit on that, Nam, if you have some thoughts on that.
Well, yes, as Tony Nguyen have shared, I think that because Vietnam is a civil law country, so that's why even we have the need to conciliate the land issue, the land dispute for a long time ago. But in Vietnam, we only in the 2014, and then we have the 2013, we have the law on grassroots conciliation. And then that law, I think that provides the legal basis for land conciliation. However, we must observe the situation that the grassroots conciliation is on the voluntary basis for the disputing party, and the party, if they have the dispute, and then they have the right to agree, or they have the right to refuse the mediation. So that's why if in the grassroots level, if even we at the commune level, they always say that the conciliation of land dispute is a mandatory procedure. However, if it comes into the end, and then if everyone happy, then I think that there's no need to go further. However, because in Vietnam, people are different, so that's why they always say that conciliation have no legal value, right? So that's why even the agreement, the conciliation agreement have been obtained, but they tend to break that, and then at the end of the day, they either go to they bring together to the court, or they can get fighting together by what we call what we call the under table law. That means the law that for that means what we call the illegal activity. I would believe that that means about 6 years ago, 7 years ago, when we have the law on grassroots conciliation enacted. But it is too early to give the concluding remark about the impact of that law to conciliate the commune level of land dispute. And then I think that so we have to go back to the main how to say the main issue here is we have to empower the people, the conciliator who do conciliation of the land dispute. Whenever people in the remote area or in the mountain area, if they do not believe on the legal value of the conciliator, then I think that they would choose others to resolve their dispute. So I don't know that that one could be a similar situation with Indian or not, but just this is a part of our culture here is the mediation at the grassroots level. Yes, that is good to do so, but let's to see what is going to happen at the end of the day.
Well, I think telling you that the fact that you said that people might not in some way abide by that settlement agreement that they get into, those aspects, I think that is not easy to rectify, that you can make that settlement agreement as good as a court decree. That takes nothing. It takes 2 sentences in a act to do that. So I don't think that is something we should easily to do something. But Tony has to tell us a little bit more on the statistics. Tony, is there do we have any statistics on how successful these on the grassroots level this is happening, and also a little bit on the court cases in general, what are being filed in Vietnam? Do you have some statistics somewhere?
I think in my presentation, I share that for the land disputes, the successful rate is over 82%. So it's quite a high rate.
But in terms of numbers, do we have numbers there? Do we have any actual, because this is
on the total number, unfortunately, I don't have that now, but I guess it's it played the biggest number, because this is the type that disputes that happen every day, right, in your daily life.
I'm just trying to understand that in terms of the number of cases which were being filed in courts, has that reduced because of this? Do we have some statistics on that?
We haven't got the specifically for the land, but I think for the civil cases, I learned that in 1 year it was about 400,000. It's quite a large number of civil cases in court, and we assume that before it goes to court, there must be a lot more numbers of cases already settled. So we can assume that the number of cases in the whole country each year should be in the terms of like a few 100,000 at least. I think it's quite a lot. Yeah.
No, but I'm just trying to. I mean, this concept, like I said, is really good that at the grassroots level this is being developed. But also we can see the statistics and we can actually see that the matters going to court reduces. It should be widened. I mean, right now you're talking about land disputes, and actually all disputes. Why should only be land? It can be all disputes at the earliest level, whatever can be sorted. So
one of the shortage of the Vietnamese legal system is that we do not have a very good, reliable figure database on the number of cases of different categories. I think we try to do the research on that,
but how much time does it take for a case to get actually resolved in courts? How much time does it take?
It was said to be over 50%, but I doubt that the problem with the courts annexed mediation is not about the successful rate, which is always above 50%. But the problem is that the result mediated settlement was not voluntary. It was a result of some it's a little bit difficult to categorize it, but it's under some certain duress.
Absolutely.
It's not a totally free, like freedom of agreement.
You write this,
under a stick. If you don't do this, then the stick will be on you.
Exactly. This is what I keep repeating. I'm a major critic of the whole concept of court annex mediation, and you will hear me so many times repeating the same thing over and over again, that the courts were for a certain function. Mediation is a totally different concept of dispute resolution. But I think there is a hangover which I've been able to understand. For some reason, we connect dispute resolution and courts and dispute resolution and lawyers. Dispute resolution is much wider than that, than where courts have to come in and where lawyers have to come in. I think that aspect of it also needs to be discussed, that where that mindset came in, because we before in the afternoon, I mean not really afternoon for you, but we had this session with a person from South Africa, and this is what she was talking about, the psyche of the people, and we were discussing this aspect, that this whole colonial hangover of the court system being ingrained into people, that I think first of all needs to come out, right? Because otherwise, why would you connect mediation and courts, which is actually totally a different process, and forcing people to do it in various places like Italy? Giovanni is there, talks about mandatory mediation. Just for what reason would you push someone into a process which is totally different from what you were set up for? And I was explaining from in terms of the Indian context, the kind of matters that we have pending in courts in India, for a judge to be sitting or even spending time with some parties to talk about, say, a divorce matter, talking about, yes, you should go for mediation, while there is someone sitting in jail whose right, basic freedom has been taken, he could be innocent. That matter will not be taken up, and this matter gets taken up. Why should they be getting into it? So what I was thinking was, should we have a dispute resolution counseling center, maybe a call center, and people can just call up that call center and talk about various options in terms of dispute resolution, and that center can counsel them and tell them what options there are and why they should be looking at those options, rather than a judge's time. I don't know how busy your courts are. Like, that you can tell us how busy they are, how many cases are pending, and how much time does it take for the case to get resolved. But in countries like us, there's so many matters that you can't have a judge spending time on these aspects of whether you should be going for mediation or not. You've come to the court for a certain purpose. You have to, they want the decision from you, that give it to them. If you can't give it to them, close the courts down. What else can you do?
Yeah, may I intervene just
Please.
one small point? We don't have the figures of the previous years because it was maybe historical issues. But for the first 9 months of the implementation of the mediation, the law on mediation and dialogue 2020, what I got from the website, the official website of the government, is that in the first 9 months, there were 2,047 cases settled, being brought to mediation, court annex mediation, and it was settled by 2,082 cases, and the overall percentage of the cases successfully mediated was 57%. And only in the first 2 months of 2021, well, for the new law, there were over 100 cases in the 16 provinces that started using the new law. So this is a few figures for an overview of what has been performed by the courts in the first 9 months of mediation.
But Tony, how much does a mediator in the court system, how much does a mediator get paid?
I think I got it somewhere, but it's very limited. It's
Exactly.
I think it's sponsored by the government, so it's.
So imagine, what are we doing?
I think that I think that Tony is true to say that because for the what we saw, the conciliation center that affiliated to court, normally the head of that center must be from the court, and then if he's appointed from the court, that means he is kind of civil servant, and then he got the we call it the monthly salary from the government. And so I think that we do not count that if he worked for that center and then how benefit that he can get it. In Vietnam, we consider that that is a obligation rather than the beneficiary.
No, but this
sorry,
is for
Professor,
the
I have the figure now. I have the figure now. I just read it from the law. It is a decree. Yeah, it is the decree 16/2021, which provides that each mediator will receive 1 million Vietnam dong and no more than 1,500,000. 1 million is about $40.
This is where I'm saying this is where the problem lies. Exactly. This is what
no more than $70.
Look, I tell you what I've been saying. Yeah, exactly.
Successful mediation.
I tell you what the situation. This is what the problem is. They are going to finish off the profession for $40 for a mediation and talking about successful mediation. What I'm saying is, what I've been saying now is that why doesn't the court set up a litigation center? And whoever lawyer wants to practice in that court gets registered with that and is paid $40 only per case. Let us see how the lawyers react to that. But mediators are supposed to be the nice people. They should not react. They should get that $40 and be happy. The profession should not develop. Why should the profession develop? It's not good for anyone, it seems. I think we need to question that, and Naam is going to be getting into it. He should get into it, that why should this disparity happen? If litigation and mediation, give them both the options and no more than $40 to a lawyer. Nothing more than that you can charge. Why do we want to control and regulate mediation in this manner? I get so surprised, and this is not in Vietnam. Everywhere they're doing this. I mean, if you want to finish off a profession, there are better ways. Just shoot down all the mediators. Just finish off the profession.
Yes, Vikram, I think that we need to consider about the keyword here, that means to how, to what extent the conciliation center is dependent from the court. And then I think that if it is still affiliated to the court, then it must be a part of our what we call the how to say, the under the umbrella of the court. So do you have any suggestion for us to overcome that situation?
my suggestion is that people should understand that mediation is a separate process, litigation is a separate process. So you have whatever you want to tell people about mediation and develop the culture of mediation, it has to happen outside the courts. People cannot connect courts and mediation for sure, and and mediation and free for sure. If you have a long-term vision for the country, finally, what do you want? Matters should not come into courts. If the matters do not come into the courts, judges will have more time to look at the more important things that they were for, that constitutional responsibility they have. They have to look at interpreting laws. They have to look at criminal cases. A person's rights have been taken away by you putting him in the jail. You have to be able to give him justice in 1 minute. I ask any judge in the world, would you like to go into jail for the time period that you have sent so many people who are innocent? At some point of time, they were acquitted. But do you want to go in for that much time waiting for some kind of a justice to be given, which is not justice? Delayed is justice denied. And what is delay for a person, innocent person sitting in jail? 1 minute is also justice denied. On what basis? If you cannot handle the system, you cannot give the person immediate justice. How do you take away his rights? You've taken away his freedom. He's innocent. You've taken away his freedom by putting him in jail. And what are you doing? You're counseling on divorce matters with someone. I mean, they have a much larger role to play, which they forget. And we were discussing this today only. It has become a case number. It doesn't matter whether the person is lying in jail or there's a divorce proceeding. It doesn't matter to them. It's just a case number for them. It is a much larger thing. So they have to understand that the whole environment of mediation and the culture of mediation will happen totally unconnected with courts. And that if you are going to give them $40, which supposing, let's just look at lawyers. First of all, why lawyers? Mediation is something that anyone can do. A lawyer can come in for his legal expertise like any other expert can come in. You can call any expert in a mediation. If there is some legal issue, they can call the lawyer into it. But for some reason, this whole connection of this, like I said, this colonial mindset that countries have, that courts are the places to go for any dispute resolution, all that mindset. But that's why now I think that aspect of psyche, psychological issues of past, all those things, I think you need to study, and maybe we have to go back to certain things, change them from where they started. It could be 300 years back, 200 years back. Where did this mindset change? Because if Tony is giving us, and you Vietnam has understood that the grassroots, there is so much available there in terms of dispute resolution in traditional forms. Definitely we should not let it finish. And the advantage that you have a 65% rural population, which is something which at least you have an advantage. You have such a large population which still understands that. The cities might have gone into this whole individualistic aspect of living their life, and society definitely has changed. That restructuring of society has to be discussed. Definitely. Where have we gone wrong in that? But that's a totally different thing. We have to also start those conversations. But we have some base available to us. I think we should be exploring that and looking at strengthening those people. If in villages certain people are trusted, those people are our natural born mediators because they've been trusted by parties. What better can you get in terms of someone's rating? The parties trust them, the village trusts them. So let us strengthen those people, bring them into the fold, let them develop it into a profession. How will the profession otherwise develop if the right people are not part of it? How do you give a person a good user experience if you don't get the right person into it? All this aspect of training and everything, there is so much emphasis on. What about the natural born mediator who's doing it in schools, communities, villages? They're doing it all the time. They are, so a lot of them not recognized also, because no one puts value to something where you settle something. People would put value to lawyers who can make you fight for 20 years. We put value to it. We give them fees all the time, but the person who's helping you settle $40, that is the value of a person who helps you resolve a dispute. This is injustice according to me. So, but anyway, I mean, Tony, if you just want to give your final words, because we have to start David's thing. So final words, and then we'll take Nam's final words, and we'll start David's.
Thank you. Thank you very much, Vikram, for very straight to the point comments. It's really great. I think that the only thing left is that we cannot forget that Vietnam is embracing a lot of FDI. So we are developing like an economy which is open to the world. So there will be a lot of foreign companies joining the businesses community in Vietnam, and they are more familiar with the mediation process than the Vietnamese enterprises. So we will need to accommodate that into our commercial mediation practice, so that it will become part of our normal daily life dispute settlement, apart from the grassroots disputes, which are not always related to commercial disputes.
Perfect. Yes, Nam. Final words.
Well, today attended our symposium. Also have the Mr. Giovanni and David Simone from Italy. I have been to Italy for 3 times, but I think that I never observed the court annex system in Italy like in Vietnam. I think that because of the law just have been enacted for several years, so it needs time step by step in order to evidence that the law will go into effect. And then, however, but I am also very confident that what Tony Nguyen said, that when we increase the FDI in Vietnam, and then we have more and more business transaction. So that's why that was the reason that I joined the VMC, the Vietnam Mediation Center. And then on the presentation, Tony Nguyen also pointed out about the MedUp. So MedUp, it is really a good solution for the online dispute resolution. And we hope that that MedUp can be, that will be the leading program from the leading mediation center in Vietnam. So because it is not difficult to scale up, so I hope that we shall scale up what we call the MedUp into other centers in Vietnam, including the Hanoi International Arbitration Center. They do have the same, and then I believe that we do have the future. Thank you.
Yeah, perfect. Because I'm with this commercial thing that you spoke about, commercial aspect of it definitely is important, but we definitely have to have the larger picture on the whole concept of development of mediation, because that is a very small percentage. Institutional mediation and everything is a small percentage of mediation which will have to happen in a country. So we'll definitely keep that discussion going. Thank you very much, Nam. Thank you very much, Tony. Excellent presentation.
Very much.
And
thank you.
Giovanni and David had something to ask, but I haven't been able to take that up because definitely there was all the other things. We'll have the discussion with them later. Okay,
Vikram, so if your symposium would be extended, then I would be willing to do another section in another suitable time.
Sure. We'll work something out for you. Not a problem. Okay.